Welcome to Legal Lines. My name is Tom O'Shea, the host of this program that is brought to you by the York County Bar Foundation. My guest today is attorney Timothy Norton, and the topic is the Patient Protection and Affordable Care Act. Tim is an attorney with CGA Law Firm. He practices mainly in the area of employment law as well as healthcare law. Welcome, Tim.
Thank you.
And like I said, we're talking about the Patient Protection and Affordable Care Act. That is a topic that has been in the news a great deal over the last few years. Most recently, in June, the United States Supreme Court ruled that the act was constitutional. And I know there's a lot of controversy about that.
Right.
But we're not going to talk about the controversy. What we're going to focus on is what is the act and how it affects basically the average household. Okay? So, when it comes to this act itself, I noticed, first of all, it's called, the official name is the Patient Care and Affordable Care Act. And before the show began, you told me it's broken into two main components.
That's correct, yes. The Patient Protection and Affordable Care Act is broken into two components. The first component deals with strictly the patient protections under the act that many consumers are well aware of. The second component deals with the affordable care provisions. And just to touch briefly on the affordable care provisions, that's where doctors and hospitals will come together to form what's known as an accountable care organization.
Okay. Now, like you said, we'll focus mainly on the patient protections, but the affordable care is, as I understand it, are various rules and regulations that apply to physicians' offices as well as hospitals and other healthcare providers as to how they need to be structured in order to meet requirements under this law.
That's correct. They're not required to form an accountable care organization, but if they decide to do so, to provide better quality care to consumers and beneficiaries through their group health insurance plans, then there are certain rules and regulations they're required to follow.
And I assume there's some type of incentives to get hospitals and patient care providers into these plans.
That's correct.
Okay? And if you're a hospital or patient care provider, talk to Tim or someone else who knows something about this, because it would be extremely complicated for us to talk about that program on this particular program. So instead, what we'll focus on is the patient protections. And by patient protections, we're talking about the requirements that the health insurance companies now need to provide under this new law.
That's correct.
Is that fair enough to say? And I think one of the first things that people talk about is that there are basically exclusions for pre-existing conditions, or no exclusions for pre-existing conditions, I should say.
That's correct.
All right. Now, previously each insurance company had the right to decide whether or not to cover somebody if they had a pre-existing condition.
That's correct.
Fair to say?
Correct.
So if someone had a history of cancer, even though they're in remission, the health insurance company could say, well, I'm sorry, we're not going to insure you.
That's correct.
You're too much of a risk.
That's correct.
And as I understand it, the insurance company can no longer do that.
As of in 2014, the pre-existing conditions will be the insurance company will no longer be allowed to exclude individuals or consumers based on pre-existing conditions.
You pointed out something very important, and that is that starting in 2014, this will begin.
That's correct.
And there are provisions under this law that get phased in over time.
Correct.
When did the law go into effect?
The law was signed by President Barack Obama on March 23, 2010.
All right, and did it become effective immediately?
That is the effective date, yes.
All right. But there are certain provisions that go into place over the next several years.
That's correct.
And the rule with respect to pre-existing conditions, that goes into effect in, January of 2014?
January 1, 2014, with the new plan year. So most employers and most health insurance plans begin by calendar year. Every new calendar year is a new plan year. However, it may, for some health insurance plans, they begin July 1 of the calendar year. So for those health insurance plans, if they begin on July 1, that condition will apply to them July 1 of 2014.
So starting in 2014, when the plan changes for its new, fiscal year or coverage
new contract year?
Contract year, there will no longer be exclusions for a pre-existing condition.
That's correct.
Now, So let me ask you this though: are there certain people now who are excluded, with pre-existing conditions where they're not excluded?
That's correct. There is now individuals under the age of 19.
So if they're right now that went into effect immediately.
That was effective immediately with the new plan year after the signing of the act.
So if there was a family that was covered by a plan and previously they had a child who, let's say the child had some form of cancer at one time, okay? The insurance company under the old law would have been able to exclude that child from the plan.
That's correct.
But because the child is under the age of 19, that child cannot be excluded today,
Right.
long
That's
before
correct.
2014.
Right.
Okay? But if there was an adult under the plan, let's say the employee or the employee's spouse was excluded, that starting
person
in
can still be excluded till 2014. The plan year in 2014.
And so is there any health condition that will still, where someone can still be excluded under the new law?
No.
Okay. So no matter what someone's previous health condition was, starting in 2014, the insurance company has to cover the person.
That's correct.
Can they charge an extra premium because of it?
No, not based on their condition, no.
Okay. So they're in the plan the same as anyone else who doesn't have the pre-existing
That's correct.
condition. Okay. One of the other things that the new law provides is for dependent care to be at an older age. Well, what is that age?
The age is 26. You can be, a dependent can be on their parents' health insurance plan until the age of 26.
So if, let's say that the family is traditionally covered by the father's health care insurance, okay? And there's a child that's in college. Under the old law, would that child still be covered by the parent's plan?
Yes, the child is in college. If he's a full-time student in college, he would still be covered.
Okay. But then when the child graduated, the insurance would stop.
That's correct.
Even if in these hard economic times, the child did not find employment that provided with the child with health insurance.
That's correct.
Under the new law, the child can stay on the parent's health insurance until when?
Till age 26.
All right. Now, when did that go into effect?
That was effective immediately with the new plan year.
Okay. So that would have been in effect right after it was signed into law in March of 2010.
That's correct.
Okay. The next thing I understand is they stopped caps on lifetime limits.
That's correct.
All right.
Lifetime limits.
What is a lifetime limit?
A lifetime limit would be let's go back to the cancer situation. An individual has leukemia and is receiving treatments for that leukemia, and those treatments are very expensive. The health insurance plan may only have a $2 million cap on cancer treatments, no matter what kind of cancer it is, and that individual may meet that $2 million cap, and they're done. Their treatments will no longer be covered, or any other treatment or anything related to their cancer would no longer be covered. So and the individual would have to pay for it out of their own pocket.
Which most people, if they reach $2 million worth of medical bills, probably are not going to be able to continue to pay.
That's correct.
So under the prior law, most insurance companies had a cap of some sort. Okay? Under the new law, the insurance company is not allowed to have a cap?
Not allowed to have a lifetime limit cap.
A lifetime cap.
Correct.
They are allowed to have some other caps.
They are allowed to have annual limit caps.
Okay.
And beginning in 2014, the annual limit cap will be $750,000, or is required to at least be $750,000. The insurance company can, of course, up the cap to $1 million or whatever they choose, as long as it's greater than $750,000.
So they have to meet the minimum threshold of the new law.
That's correct.
Okay, so if somebody had a serious disease, where we seem to select cancer, let's say somebody had cancer, they had a very aggressive treatment plan that was extremely expensive, and the cap was $750,000, and they met that cap, let's say, in October.
Okay.
They're uninsured until January when the insurance...
When the new insurance contract year comes up in January, that is correct. They can't get the treatments without paying it for themselves. However, in 2015, of course, the cap moves to $1.25 million, and then in 2016 it goes up to $2 million. So the annual limit will increase.
It sounds like the annual limit is going to be roughly the same as what most lifetime limits were before the law.
Well, maybe.
Okay. There's something that you told me before the show. No rescission in benefits.
Unless fraud or intentional misrepresentation.
What would cause a rescission of benefits?
Prior to the
Right.
Prior to the law, pre-existing condition could cause rescission in benefits. Of course, if you didn't inform the insurance company of that pre-existing condition before being placed on the health insurance plan.
Oh, right. Under the old law,
Right.
people who had pre-existing conditions sometimes neglected to tell the insurance company.
Correct. They may not have known about the pre-existing condition. However, some provisions in the insurance plan would provide, if you get this disease and you've shown you've had symptoms, you've been going to the doctor and you just haven't been diagnosed, that could be considered a pre-existing condition, and your benefits could be rescinded.
Okay, but now you can only have them rescinded if you committed a fraud when you signed up for the insurance.
That's correct.
Okay, there's something that's known as an appeal process.
That's correct.
That the law provides. Can you explain how that works?
And the appeal process would work if an individual is denied a benefit under the plan. They receive something in the mail from the insurance company that says, we will not be covering this benefit, you will have to pay for it out of your own pocket. They can now, under the new healthcare law, the insurance company is required to set up an external review process where they are required to contract with a company to review their denial of the claim based on the terms in the plan documents to decide whether the insurance company properly denied the benefit.
Okay.
And if the individual exhausts the external review process, then they can file an action in court.
Okay. Now, there are certain benefits which I believe the broad category is women's health issues.
Correct.
Under the new law.
Mm-hmm.
And I believe that most of these just went into effect?
They did.
Okay.
They've already been in. They are.
All right. And can you tell us what women's health issues are covered by this new law?
One of important change is the nursing mother accommodation. And under the ACA, it amended the Fair Labor Standards.
ACA.
The Accountable Care Act amended the Fair Labor Standards Act, which now employers are required to provide nursing mothers with a private room to pump milk within a year after the child's birth.
So if a woman goes back to work within a year of the birth of the baby, there has to be a private place at the place of employment where the mother can not nurse the baby,
but express breast milk.
Okay.
Mm-hmm. And the employer, it has to be a private room, and it can't be a bathroom. It has to be a room that she can go into and close the door to express the milk anytime she feels necessary to do so.
So it's not necessary at lunchtime or coffee break time. It would be any time.
Any time throughout the day she needs to express milk. It is unpaid time, so the employer does not have to pay her for that.
All right. I understand, too, that there's some requirement with respect to paying, the insurance companies have to pay for
the birth control
pills. Right. Okay. And also, are there rules with respect to a gynecologist?
Yes. A woman is now permitted to choose a gynecologist outside the plan.
So if a woman feels more comfortable with a gynecologist that's not one of the gynecologists within the plan of the insurance company, she may choose to go to that gynecologist.
And she would still be, and the plan still requires to pay for it as if she was in market.
All right. We're almost out of time for this segment. We'll be back. This is Legal Lines. Welcome back to Legal Lines. My name is Tom O'Shea, the host of this program, and my guest today is attorney Timothy Norton of CGA Law Firm. We're talking about let me double check the correct name, the Patient Protection and Affordable Care Act. This is the new health care law that went into effect in 2010, was ruled constitutional in June of 2012. The purpose of today's program is to discuss what the Act actually provides for the average consumer, the average person covered by health insurance. And we went through briefly to recap the patient protections, which include dependents can be covered now until the age of 26. There are no lifetime caps on the limit of insurance that can be provided by a company. There are no no longer exclusions for pre-existing conditions. That exists right now for children. Starting in 2014, it applies for adults as well. There are certain benefits for women's health care issues, including birth control pills have to be covered by insurance, including women can use gynecologists that might not be covered by the plan that their employer provides, and still the insurance company would have to pay. We also briefly talked about the appeal process if somebody's denied some benefit under the plan. I want to talk now about grandfathering, because that's something you mentioned before we began the program. What is grandfathering?
Well, if you can recall back when Congress was debating the act and President Barack Obama was going around talking about the act, he said, you can keep your plan if you like your plan. And that's where this grandfathering concept came into play. Which grandfathering, whatever plan was in place that you were covered under on March 23rd, 2010, the date the act was signed into law, if that plan stays the same, absent a few changes, then that plan is considered grandfathered. And the reason why that's important is some of the patient protections, if the plan is grandfathered, do not apply.
Okay, but there are certain new provisions that apply regardless of whether it's grandfathered.
That's correct.
Like the age 26 exists no matter what.
The age 26 does not exist no matter what.
Oh,
if your plan is grandfathered, the plan can choose not to offer the dependent coverage if that child is employed elsewhere and that child's employer offers health insurance.
So there's a limitation to it.
There is.
Okay, so in other words, if I have a 24-year-old son who has employment where health insurance is offered, and my son says, well, I'd rather stay on your health insurance because it costs me nothing, or I'd rather stay on your health insurance because it has better coverage. If he has health insurance through his employer, and I'm grandfathered, and my plan is a grandfathered plan, he has to get his own health insurance.
That's correct.
And he does not have the right to stay on mine.
That's correct. The insurance company can deny him coverage.
On the other hand, if my plan was not grandfathered because it changed after the new law went into effect, then I could say to the insurance company, I don't care, he can get health insurance through his own place of employment. This isn't a grandfathered plan. You have to cover him.
That's correct.
All right. So the benefit would be so employers do not change the insurance year to year.
That's
like
correct.
Many employers have done in the past.
Right. That's correct.
Do you know if, it's only been 2 years since the act went into place. Are most plans grandfathered or non-grandfathered?
Most plans are non-grandfathered because of the changes that can take you out of grandfathered status, such as increasing premiums to a certain percentage or increasing co-pays. As everyone is well aware, health insurance increases drastically every year.
So for a company to be grandfathered into the old plan, they could not require the employees to pay a higher premium.
Well, within a certain percentage, which the percentage is very, very low.
I see. Okay. The other part of the law that has a lot of controversy, and I don't want to get into the politics of this at all, but as I understand it, is the individual mandates.
That's correct.
Okay. Now, what are the individual mandates?
The individual mandate is required by the Act if the individual does not have health insurance coverage. Health insurance coverage will be available through an employer plan, possibly through Medicare or Medicaid if the individual meets the requirements to be covered under those payers, or the health insurance state or federal exchanges. If the individual does not have health insurance, then the individual is required to pay a tax penalty.
Okay. Now, for the individual mandates, number one, is that something that is already in effect?
That is not in effect as of now.
When does that go into effect?
2014.
So January of 2014?
Yes, January.
Or if the plan starts mid-year, then it waits till mid-year.
Right.
Okay? So starting in 2014, let's say I'm an employee of a company and the employer offers a health insurance package, and the package would cost me $100 a month out of my paycheck. And I say, well, I'm young, this is back in the day, but I'm a young employee and I have no health problems, and I decide to say, I don't want to spend $100. How does the individual mandate affect me?
Well, in 2014, the individual mandate will require you to pay a penalty. The penalty would be $95 or 1% of your income, whichever is greater.
Is that per year?
$95 that is per year, yes.
So some young person right out of school, just starting a career, who's very healthy, might choose to pay the $95 than buying the health insurance anyway.
Right. Well, or the 1%. I mean, it depends on how much income they have. That would be a business decision for them to make. But yes, they could choose not to get health insurance, and most likely would, depending on what their circumstances would be cheaper to pay the penalty.
Okay, but then they wouldn't have health insurance.
That's correct.
Okay.
But again, that wouldn't matter in this case because pre-existing condition exclusions is gone.
So then they can later choose to get the insurance without worrying about the fact that now they have a condition where they need the health insurance.
That's correct.
$95 or 1% of the income doesn't sound that expensive. Are the rates going to go higher?
They are. In 2015, it will be $325 or 2%, and in 2016, it'll be 2.5% or $625, and of course, that's whichever is greater.
So it's whichever is greater. So once the law goes into effect for a few more years, I assume that's the intent of the law, is that more people will say, I don't want to pay the extra penalty, tax, whatever you call it.
Right.
I will be responsible and get my own health insurance.
That's correct. But again, I mean, an individual making $58,000 a year would only have to pay about $1,400, which would be 2.5% of $58,000 in 2016, or of course $625. So he would have to pay $1,400. But depending on, again, you do this as a tax, so that individual may have circumstances where they're actually still getting money back, but they're paying that penalty to take away from their reimbursement from the IRS when their taxes come out.
Right. But they don't have the health insurance.
That's correct.
Okay, but they can sign up for the health insurance at any time.
At a later date.
At a later date without worrying about the pre-existing condition.
Correct.
So it'll only be the medical bills that they incurred until they get on the insurance that'll be at risk.
That's correct.
Okay. There are mandates for employers as well as individuals.
Correct.
And how do they work?
The mandate for the employer is, first of all, if the employer doesn't offer coverage or doesn't offer sufficient coverage. If the employer doesn't offer coverage, the employer has to pay $2,000 penalty per full-time employee employed with the employer.
All right, now
as a no coverage penalty, excluding the first 30 full-time employees.
Okay. To make it clear, do all employers have to provide health insurance to employees now?
There's no requirement that the employer has to provide health insurance.
But there's a penalty if the employer does not.
That's correct.
Does that apply to every employer?
That only applies to employers with 50 or more full-time employees.
All right.
But there is a caveat here. A full-time employee is defined as an employee who works 30 or more hours a week. And to decide whether the employer is subjected to the penalty, part-time employees will be added up to make a full-time employee.
Oh, so if there were two people working 20 hours a week, or even two people at 15 hours a week,
they
would equal one full-time employee. Mm-hmm.
That's correct.
And if there are less than 50 employees, the company does not have to offer any health insurance.
Well, the company doesn't have to offer health insurance, period, but the company will not be subjected to the penalty.
So if there's an employer with over 50 full-time employees, or the equivalent of 50 full-time employees, if that company does not provide health insurance benefits for its employees, they're subject to the penalty.
That's correct.
And that penalty is how much?
That penalty is $2,000 per full-time employee, excluding the first 30 full-time employees.
So excluding the first 30, even though they are allowed to have 50 employees without doing anything.
Right. So if they have 50 employees and they don't offer coverage, they have to pay $2,000 per employee, excluding the first 30. So it would be 2,000 times 20 would be the amount of the penalty that they would have to pay.
I'm glad you can remember all of this. It sounds very complicated. I said I wasn't going to get political, but I think this is something that only Congress could create.
It is very arbitrary.
So I'm glad you have all the details down. But are there any benefits for a small employer, let's say a company that has 20 employees, to offer the health insurance, other than what existed before the law was in effect?
Other than what existed before the law? No, not. I mean, there are certain tax credits, but those are phased out by 2013.
So, I mean, many small business people have companies that offer health insurance, even though they have a limited number of employees, far less than 20. Mm-hmm. Okay, far less than 50, I should say.
Right.
Okay, there's nothing under the law now, under this new law, that would change what that company has to do.
No, there's nothing under that would change. No.
Okay. So this only targets, if you will, companies with more than 50
or more.
Or more. Okay. Now, there's something else we talked about briefly before the show began, and that's called free choice vouchers. It sounds very complicated to me, but I'm going to let you take over.
All right.
What is a
free choice voucher? Is a requirement under the law beginning in 2014, whereas if an employee requests this free choice voucher, the employer is required to provide it. The employee has to qualify for the free choice voucher. The way the employee qualifies for it is if the employee's household income, that includes the employee and the spouse of the employee, if the employee is married, is between a certain figure, which is if 8% or 9.8%, if that employee's household income is between that percentage figure, and what that means is the percentage is taken on the employee's cost of the health insurance. So, for example, if the employee makes $50,000 a year and the employee has to pay a percentage that will be between 8% and 9.8% for health insurance coverage compared to that employee's household income, that employee will qualify for a free choice voucher. If the employee meets one other requirement, which is the income level, if the employee's income is 400% or less above the federal poverty level. What that means for a family of four is if a family of four to be 400% above the federal poverty level has to make $92,200. The reason why this is important is the employee can request a free choice voucher from the employer, and the employer is required to provide them a tax-free voucher at the employer's costliest health insurance plan. So if the costliest health insurance plan is $10,000 a year for a family of four, the employer has to turn over a $10,000 voucher to the employee and say, here you go purchase health insurance on the exchange.
And if the employee finds health insurance that costs less than that $10,000?
The employee can keep the remainder in cash.
Okay, so
tax-free.
The incentive here, as I understand it, is so that the employer offers affordable plans for the employees?
That's correct.
And if they offer something that costs too much for the average employee, the employee can go elsewhere and the employer still has to pay?
That's correct.
Okay.
And another thing about this is if the employee goes to the exchange, most likely this employee will also qualify for a federal subsidy to buy.
I'd like to go into these details, but we are running out of time, and I know that's complicated. Mm-hmm. This is Legal Lines. My guest today was attorney Timothy Norton. We were talking about the new health care law. Thank you.